Welcome. Hello. How are you doing? Welcome to the Life and Transitions Experts podcast. Here it's Wednesday where we do a overview of the North Carolina probate process. Now, what is probate? We'll just jump right in and let you know. Well, if you're here and you're checking us out, I'm sure you are aware of what probate is. You may have recently lost someone or lost someone in the past. And for that, I offer my condolences. And you may have been charged as the administrator or the executor of the estate with handling the affairs of the estate. And that's what probate is, folks, if you're here as someone looking just for information. Probate is the process of settling the affairs of a deceased person when there aren't other legal instruments in place. Sorry, I got this bright light up here. It's been a pretty interesting evening. We're in Durham, North Carolina, and there was a huge storm that came out of nowhere yesterday, and our power is out. So now I'm at the office because there is power here. But my fiance, who works from home, is also at the office. And good gracious, I think she's Arctic or something. I don't know. She has it freezing here. So I got my sweater on, all that good stuff. And I can't get the lights right. But it's all gravy. It's all gravy. Also, I'm excited about today because I have a special offer for folks who are looking to either complete probate without possibly an attorney, but still want to do it the right legal way and economically. So there's a discount code for an awesome resource that I've been able to partner with. I'll share it at the end. Also, it's a great resource for folks who want to have an estate plan set up so that they can avoid probate for their family in the future, so that you can, if you need to create a will or create trust to help protect your family's legacy, you'll have that discount code as well. So as a matter of fact, spoiler alert, just hit me up, DM me for the discount code if you would like that and don't have time to wait till the end, all that good stuff. All right, so let's go ahead and go without further ado. I'll share my screen and the probate workshop. All right, as we say, this is the Durham County, specific to Durham County, North Carolina. However, it does pertain to all of North Carolina. There may be some nuances that are non-legal with the way people do things that may be different in different counties, but overall it's the same thing because in North Carolina, it's governed by the state law. If you're outside of North Carolina, probate does look different in different counties or different states. The general idea and just the same, maybe different names. And again, there may be some different processes. If you need someone specific to your state, reach out to me as well because I'm connected to a nationwide network of vetted estate professionals. So we'll find someone to support and help you. All right. And so this is, I'm spending my time constantly at the Durham County office. The clerks, the deputy clerks are amazing. They're always so supportive and helpful to you if you need support in the Durham County office. And at the same time, as government officials, their hands are really tied. They can't offer any type of opinions at all. I can offer my opinion, but I'm not an attorney or a financial advisor, not giving legal or financial advice. And they certainly won't give any of that advice because they can't even give their opinion, but they want to help so much. So I'm thankful to them to allow me to help with this workshop to help folks just shed a little light on some of the things that may be unclear if you're actually going through probate. And we've already discussed that it is the process of selling the affairs, the estate of a deceased person. The state has to be zeroed out so that life can keep on being lived by those who are are here, and there aren't anything tied up in someone who's not able to make decisions anymore because of their transition. These are pretty much the steps of the probate process. You're going to go and open probate, depending if it's a large estate or a small estate, or depending on the size of the estate depends on the type of probate you'll go through, if it has to go through probate. Then you'll take an inventory of all the assets and reach out to all creditors in the steps that are taken to make sure that they can address any claims or issues, pay all the debts, taxes, distribute inheritance, do the final accounting, and close the estate. So when you open probate, you'll please note that there's two things: whether there's a will or not, you'll still have to. If there is a will, you'll still need to go through probate. That is actually the way a will is actually executed, through probate. So some people may assume that a will prevents someone having to go through probate. That is not the case. A will is great protection to get someone's last literally will testament out there, but it doesn't stop them from going to probate. Someone has to go through it. If there is a probate or a will, then there will be an executor or executrix or multiple executors or executrix that are involved that that do the work. Executor, executrix is just gendered name of the same, role. And if you are noted as the executor or executrix of the estate, you may need to be bonded, but usually in the will, they'll waive the bond because this is a fiduciary responsibility. And want to make sure that if you're handling assets and all and debt and things of nature, that person knows that they're responsible and there's consequences if they don't follow the steps properly with good faith. And if you decide to renounce that, then you can. You'll just have to fill out the form to renounce your position. If there is not a will, then this is more of an administration. The state is administrating it, and you can be the administrator. Anyone with a vested interest can be an administrator, whether that's a family member or even a business associate who's expecting some assets from this, or someone who has owed debt. Anyone can be the administrator. And then the judge or clerk will decide who the administrator is. There's multiple people, and usually a person with closer proximity to the person decedent will receive that judgment, but things change. So first step is to open probate. Please note that if you're calling Durham County, it's probably going to take 4 to 6 weeks for you to get in for most cases. So it's a lot of hurry up and wait, but it is that's just the nature of the beast. So make sure you call down there and get that scheduled. Also note that there is a filing fee. I believe at this time of the recording is $120 that you can pay at Durham County or other court offices. I'm sure they have ways for you to pay in those counties as well. But there is a filing fee to open up court. You will receive, you'll receive your letters of testamentary if there's a will, or you'll receive your letters of administration. And those letters officially say that you are the personal representative and have the legal authority to act on behalf of the estate. That means they'll give you access to titles, deeds, bank accounts, things of that nature. You'll begin to make an inventory of all the assets, and you need to make sure this is down to the dollar. So let's say there's a car. You can take the car. It's 1965 Dodge Challenger. You look it up perhaps on Blue Book somewhere and print off the value that they state there, and you'll list that there. Same thing with property. If you don't know the property assets, you can go to Zillow, Z Estimates, things of that nature. Even though they're not necessarily as accurate as I would have assumed in the real estate world, they can be used to help support, help you list out what the assets are and what you assume the debts may be. But definitely listing all the assets, all the personal property. Is $5 cash found under the mattress. You'll list that out there. Everything is listed. And you'll have about 90 days after you've opened up probate to submit a official inventory. You'll have a preliminary inventory at the beginning when you actually open probate, and then the official one will be due 90 days. If you need extensions because you're going all over the place trying to find stuff, or you just need help and need time, you can file an extension. If you need support, I have a great software, estate exec. And actually, if we give me a call, chat, we can talk. And I actually can bear the cost of it if it's going to get you where you need to be. It's like a QuickBooks for estates. You'll send out the notice of credit to the official or to the qualified news publication. In Durham County, there's two. The Herald Sun or the Carolinian are the two ones that we know are like, hey, this is authorized because of the widespread reach. Basically, people need the opportunity to see, hey, someone's passed away who's owed me money. I have the chance to collect against the estate. Once you file it, it's usually about $270 to file, and that's for 4 consecutive weeks of running. 1, 2, 3, 4. Once it's filed, you'll have 4 consecutive weeks that runs, and then 90 days, it'll stop running. 90 days after that, they'll have, as well, all creditors will have the opportunity to submit the information, their claim. And when you actually when you submit the ad, all you need is really the death certificate, and the newspapers will take care of all of that. They'll send their information over to you so you can approve it, and then they'll run the ad, and you'll receive they'll send back to you a affidavit of the notice that you'll put in to the estate file. Of course, administer the estate. That's what you're doing right now, administering the estate. You're filing the files that need to be filed at the time. You're submitting the notice to creditors when you're supposed to submit it. You're handling all the inventory. That's all the creditors that are coming in, and that's literally what administrating doing. You're administrating the estate. And one way to do that is address the debts. Now, when these debts start coming in, don't start paying them off immediately or come, first serve. No, wait till the end of the full 4 months or the 90 days after the last ran, 4 months, and then take a look at all the claims that came in. And there is a priority of who gets paid first. And it can be prorated if there's not enough funds there. It can be, hey, there wasn't enough funds for you at the end, but these had to get paid because there's a priority. Another thing I like to say is always contact each of the people that are making claims and see if you can get that negotiated down to a 0 or reduced. You may not, but can't hurt to try, and it does happen often. So see if you can get these debts to be written off and have more assets for the family to be distributed and shared. All right. You'll file taxes at the end. You'll file as long as the estate is open. Once you open probate, it usually should take you less than a year to get everything taken care of. But if for whatever reason it extends beyond, you'll have to file taxes each year. Any new income coming in, you'll have to put that in, whether it's rentals or interest payments from investments that the decedent had. You'll need to add that to the inventory each time, and of course file the taxes accordingly. So just as good to know. At the end, once all the debts have been paid, you'll be ready to administer all remaining assets. Make sure any heir that does not want their benefit, that they sign a renunciation of benefits. Any heir that wants their benefits, make sure they sign a receipt of benefits as well. You'll add that to the file. Essentially, you want this account to be zeroed out, nothing remaining, and all put in the proper legal places where someone who is alive can manage those things. All right. And then you fill out the final accounting. You'll get that approved, and your duties as the personal representative will be discharged, and you're done. You did a great job. You did a great job. All right. And so what I'm really excited about is that place called Trust and Wills. Awesome resource. I've actually, when they're first customers that I've been able to share them with them is myself and my fiance to set up our trust, our wills. It cost us less than $600. Just to give you an idea, quite often if you go to an attorney, or this trust and wills are vetted, trusted, or vetted attorneys and legal documents that you'll use, but it's just not as traditional one-on-one hands-on that you have with an attorney, which could cost you about $4,000 to $5,000 to get all your estate stuff set up. So this is an awesome, affordable way for folks who want to make sure that they at least have something in place that is legally binding, that is vetted by attorneys across the nation and of course in the United States. And if you want a discount, I have a great discount on there. Just reach out to me at stateproservice.com or 919-341-1992. Or DM me however you want and can, and I'll make sure that I get that code over to you. You can check it out, go at your own pace. Of course, no obligation, but it's helpful so that you can avoid probate in the future. Or if you need support doing the probate, obviously there's probate support there. All right. So I would love for you all to hit that like, subscribe, and all that good stuff so that we can keep doing all this good work. And other than that, I always leave you all by saying, let me get over here so I can see you folks. Where are you? There you are. Yes, let your light shine. Peace.